Libby, you're on WDBO. Go ahead.
Hi, thank you so much for taking my call. I have actually recommended you to several people, and they're very happy with your service.
Thank
But
you.
I've never used you before. But I have a question.
All right.
Thank you, Libby.
Okay, yeah. Let's see. I'm a widow. I've had for 8 years now. I have one son. I've had my home quit claim deed for like about over 2 decades now. It's in my name and everything. It's a quit claim deed. Now, my question is, I'm very interested in getting a ladybird deed to leave it to avoid probate
Right.
and to transfer it to my son and my two grandchildren. And also a two-part question: do I have to transfer it from a quitclaim deed to warranty deed in order to do the ladybird deed thing? Or
Okay.
I'm kind of confused.
And how old are
If
your
you understand my
grandchildren?
question. I knew you were going to ask that, and I think they're 14 and 12.
Okay. So
14
first of
and
all,
12.
the fact that you took title via a quitclaim deed makes no difference whatsoever. Quitclaim deed,
Okay.
warranty deed, special deed, all of them do the same thing, and that is a title to place the title to the property in your name only, Libby. Don't worry, the quitclaim deed I'm sure is just fine. Number two, you can't leave real estate to young kids, and actually, let's just say minors. Anybody under the age of 18, you cannot leave them title to a piece of real estate. So, Libby, either you need to get back to the basics and leave this home simply to your son with the understanding that your son's going to take care of his own kids. Or if you said, Tom, absolutely positively, I want my grandkids to share in the home that I live in, we would need to be using a living trust for you, Libby, so that their share of this real estate would be
Mhm.
held in this trust until they reach typically age 25. So, Libby, either way,
Right.
we'd be pleased to assist you.
Okay. Well, thank you so much. That explains a lot.
Okay, Libby, thank you for referring
Thank you
people to us.
so
We
much.
appreciate it very much. We're
Thank you.
always
Have a great day. And hello to the lady. I forgot her name.
It's okay. Happy New Year, Libby. It's Chrissy, and
Hi.
thank you so
Yes.
much.
Okay, Chrissy. Thank you so much, and happy New Year to you. And thank you. I love the show.
Thank
Thank
you.
you.
Have a great.
Chrissy, I had something happen to us last couple weeks ago that's never happened to me before.
What's that?
Well, we're doing a probate, and of course, we're all about helping people to avoid probate. But this
Right.
was a non-client that passed away that we're having to do a probate for. One of the beneficiaries of this probate estate is a minor under the age of 18. And normally we might place the title in the name of the minor. We can, putting the a real estate title in the name of a minor is easy, but remember it's stuck there until that minor becomes an adult.
Right.
That's why we don't want to do it.
Exactly.
If you put the title in the name of a 12-year-old, the 12-year-old cannot convey it out
Correct.
until a 12-year-old reaches the age of 18.
Exactly.
So if we have to, we have to. It's not a good idea, but there was no other choice in this situation. Well, our new probate judge. She says, okay, you're going to do this. You're going to have to create a legal guardianship for this minor 12-year-old. Folks, creating a guardianship for somebody, whether they're 12 or 82, is a big, 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 expensive deal. If somebody says, oh, just go get a guardianship, well, 6 months and $6,000 maybe.
I think more like 10 now.
Yeah.
Yeah.
So, boy, what a shocker on that the judge was going to require that they've never had before, but in the situation they are.
I believe that for whatever reason on their end, they are going in that direction, because I don't know that I shared with you that a probate that I have going on, the judge required the same thing, because there are two teenage children involved, and a home, probating a home, and the judge is requiring guardianship.
Good boy.
Same.
Man, that is all. Man, if you've got young kids or you've got grandkids or young,
Correct.
minor nieces and nephews you want to include in your estate,
Exactly.
and that's all the more reason to get your proper estate planning done and leave it to them via a living trust,
Correct.
not a will.
Correct. Because if you do it via the trust, then you would not have to do the guardianship.
Yeah.
But if it's within a will, then I guess it seems like the trend that you could maybe expect that now any property, any real estate that it would be leaved to a minor in a last will and testament, very likely the probate judge will require a guardianship.
Yep, and again, expensive and takes a long time.
Time-consuming.
Yeah.